and age restrictions. My name is Joan Barata. Most of you know me. I work on topics and at the intersection between freedom of expression and platform regulation. And I think that ongoing discussions about how to protect children online have very much to do with these two very, very important matters. We know that, let's say, the protection of children has been the object in the field, in different areas of communications, has been the object of legislation. We see that when it comes to the regulation of television services, radio, cinema, etc. It is not new, and we see quite a lot in this kind of legislation of a protective approach towards children. This kind of protective approach has been probably extended to the world of online service. So our online services concerns around to what extent a certain piece of content or a certain service, a certain feature can affect the physical development, the moral development, or even the psychological development of children have been present in the mindset of legislators, regulators, and also politicians tend to be very sensitive with discussions around these topics. And politicians generally, I would say, have this tendency. They want to be seen as doing something in this field to protect children. And of course, now in the world of social media, with some of the risks that, of course, are associated to the use of social media, particularly for children, this debate is particularly emerging. However, we tend to ignore the fact that minors, apart from deserving protection according to the law and according to international human rights standards, minors also have human rights and deserve or have the right to enjoy the human rights, the right to freedom of expression, the right to access to information, the right to acquire some degree of digital literacy, the right to become parts of communities, the right to interact with other minors from all the parts of the world, the right to obtain some education, have access to education through online systems. Also, let's say, the preparation of a child to, let's say, live in the adult world probably requires that before the age of 18, the child becomes familiar with the characteristics and even the risks that the online world poses. So it is not an easy discussion, and this is why when we talk about regulation of protection of children via regulatory systems, we need to think about different types of measures, about empowering children, how to empower children, how to facilitate that children are able to take proper decisions when having access to certain types of content or services. How to define the role of adults in this relationship. Should adults have complete control over what children do? I mean, it depends on the maturity of the child, to what extent even child can be protected from wrong decisions taken from adults in this field. How to protect the privacy of children and how to protect the privacy of adults when trying to protect or preventing access from children to certain types of content. How to adapt designs, the whole discussions about content moderation, recommendation systems need to be particularly adapted, and measures in terms of transparency, accountability, etc. Systemic risk assessments need to be particularly adapted also to the reality of children. This is why, let's say, talking about age restrictions and age assurance, it's only one part of the discussion, but it's a very relevant part of the discussion. But in this introduction, I wanted to emphasize the fact that we are talking about a topic that goes beyond, let's say, restricting access by children or access from children to applications, even though most of the debate is about these matters. And we see, for example, in the EU, all these proposals that also have this maximalistic approach. It's not about, let's say, restricting access to specific types of content or features. The discussions they are witnessing is on whether we should just prohibit minors from having access to social media in general. No, that's the kind of approach that unfortunately we see politically speaking. And however, of course, here ideas and principles that also come from the world of human rights, like necessity and proportionality, tend to be forgotten in the legal analysis. And this is why we thought it could be a good idea to gather some experts to discuss these from different geographical perspectives. We know that, for example, at the EU level, we have the Digital Services Act that establishes certain provisions, certain obligations for platforms when it comes to the protection of children online. The European Commission has issued a series of guidelines in this field that can be interested, can trigger an interesting debate, even though states don't seem to pay much attention to them. In the United States, of course, I mean, the impact on the First Amendment, or using the lenses of the First Amendment to assess certain types of laws that impose certain obligations in terms of age verification, I mean, are also interesting. We need to keep in mind that, for example, a very important decision from the 90s was precisely about on freedom of expression online. One of the first ones was about the famous Communications Decency Act. No, that was a famous decision by the Supreme Court precisely on this matter. And of course, in Latin America, we have Brazil that is taking already, I mean, some steps in adopting legislation, also within a context of demanding more responsibilities from platforms. But we still have, I mean, a fragmented space, but at the same time, we also have very interesting standards from the Inter-American system. So in order to cover all these different angles, we have, I think, today, I think that the experts that we have coming from different, I mean, perspectives, different countries, different regions, to discuss all these issues that I just mentioned. So my colleague Elena Lazar from the University of Bucharest will be moderating and introducing the speakers. Thank you.
Thank you, Juan, for passing me the floor. It is really a great pleasure having you all here. And it is great to have experts from all the parts of the world. So we have 3 speakers today, and I will start with introducing the first speaker and thanking him for being here. So we have Martin Sass, to whom I thank for stepping in for Dr. Aleksandra Kuczerawy. She is also present with us today, and we thank her, but due to some personal circumstances, Martin will be stepping in for her. So Martin is a doctoral researcher at KU Leuven Center for IT and IP Law, working with Aleksandra, and also an active member of the multi-stakeholder working group on gaming and regulation, hosted by NYU Stern Center for Business and Human Rights. And his research and studies aim at building a rating system based at EU law to evaluate privacy risks in digital games, of course, with a specific focus on children, which is the main topic of the webinar today. And in this context, Martin has explored and is still exploring a wide range of topics, including the necessity and proportionality of age assurance requirements to access digital services, of course, in relation to children. And in collaboration with Professor Jan Tobias Mühlberg, and I hope I'm not mispronouncing, Martin has conducted a study which was commissioned by the Greens EFA group at the European Parliament in order to evaluate the impact of age recommendation systems from a fundamental rights perspective, of course. And since then, he regularly takes position on the ongoing policy developments on the topic, and of course calls for a proportionate and a risk-based approach and implementation of these technologies, which also affect and impact children, especially in the online environment. We also have today with us Marianne Franks. Also, thank you for being with us today. Dr. Mary Jean Franks is the Eugene L. and Barbara A. Bernat Professor in Intellectual Property, Technology and Civil Rights Law at the George Washington University Law School. And thank you, because we already know that you're another time zone, so we really appreciate you being here. She is an internationally recognized expert on the intersection of civil rights, free speech, and technology. And she is also the president of the Legislative and Tech Policy Director of the Cyber Civil Rights Initiative, which represents a nonprofit organization dedicated to combating online abuse and discrimination. And she also frequently advises state and federal legislators on various forms of technology facilitated abuse, as well as major technology platforms when it comes to privacy, free expression, and safety issues. And lastly, we have Agustina del Campo. Thank you very much for being here with us, and also taking into account again, since we have another time zone, we really appreciate the effort. She has been the director of CILIS since 2016 and the researcher since 2012. And she's a lawyer holding a master degree in international law and human rights from American University, Washington College of Law. She was also a Fulbright Research Fellow at Columbia University from New York in 2015, and member of the expert group, again, for the Columbia University's Global Freedom of Expression and Access to Information project. She also worked as a consultant for the Organization of American States and also for Amnesty International Argentina. Thank you again for being here today. And now I'm going to pass the floor to our first speaker and expert, Martin Sass. The floor is yours.
Thank you so much, Elena and Joanne, as well, for this amazing introduction. I think almost everything already has been said, but I will still complement that with my presentation. So I will quickly share my screen. Just a second. Just confirm that you can see it well. Is that fine? Yes. Okay, great. So yeah, I will briefly give you an overview of the current situation that is ongoing in the European regulatory landscape, and for that purpose, here we go. I will just briefly re-acknowledge what Johan was already discussing in the introduction about the fact that protecting children online is, of course, a legitimate objective, because children encounter a very wide range of different risks when they browse online, which include content risk, which is the different contents they can be exposed to, such as pornography, violence, gambling, etc. Contact risks, which are more related to the encounter that they can make on those platforms and being exposed to sexual harassment, grooming, harassment by other people, including other children as well. Then we have conduct risk, which are more about how they themselves use the digital services for activities that can be harmful for themselves or even illegal. And then finally, we have contract risk, which are more about the exposure that they can get when using the different terms, the different services in relation to how those services are operating, and that would notably comprise gambling services, but also we can think about services that are not meant for children, or services that use personal data, for example, that are not supposed to be personal data of children. And therefore, it's important to protect them, but this also comes with a cost because, as Johan was mentioning in the introduction, we nowadays use digital services for a wide range of purpose, including the exercise of fundamental rights, which can be freedom of expression, right to access information, right of assembly association, right to education, which are fundamental rights that apply to any type of users. And by the moment that we have an age gate, they are also impacted in this way because they will have to go through the age assurance process to be able to actually exercise those fundamental rights as well. But then when we talk about children users, we also have more rights that are specific to children, such as the right to development, the right to play, and as well the rights to having their best interest taken into account, which include the exercise of all the other rights that are also they also benefit um, um, more generally. So as I was mentioning, by the moment that we put an age restriction and we actually prevent the exercise of this right, and we can also interfere with other type of rights, such as the right of privacy and data protection, because to go to the age assurance process, you will have to, at least to some extent, provide some personal information that can interferes with the right of privacy and data protection. And depending on how the system works, this like the result that end up from this process can also sometimes discriminate certain people depending on the method used and depending on how the system has been built. So if the system decide wrongfully that you cannot access the service and therefore prevent you to use those exercise the fundamental right, you also are facing potential discrimination. And therefore, since the implementation of age assurance system interfere with fundamental rights, it's important that they remain necessary and proportionate pursuant to the Charter of Fundamental Rights of the European Union, and specifically Article 52.1. And that requires several questions. First, it should be provided by law, which in the European context is the case, and I will develop on that a bit later on. It has to respect the essence of fundamental rights and freedom, it has to be necessary, meaning that it has to pursue a legitimate objective. We already saw that protecting children in the online environment is a legitimate objective, but then it should also be effective in achieving this objective and be proportionate, meaning that the negative consequences introduced by the measure shouldn't override the benefit that it brings, and that also there is no less restrictive alternative to this measure, which is probably in relation to age assurance, where most of the work could still be done either in relation to research or also what could be done by platform to put other type of measures without necessarily having to trigger age assurance. So let's now diving into the European legal framework, starting with the General Data Protection Regulation. So the GDPR actually have in its recital 38 firstly provide that children merit specific protection with regard to their personal data, and later on condition the processing of children's personal data when this processing is based on consent. It can only be lawful if the data subject is above a certain age threshold, which inside the regulation is set at 13 years old, but can also be reduced by member state up until the age of sorry, inside the regulation is set as 16 years old, and can also be lowered by a member state until 13 years old minimum, which is the case, for example, in Belgium, where I'm from. And if the children is not of this age, then there is the need for a parental consent to actually approve the processing of the personal data, if it's based on consent. And by doing so, the controller has to make reasonable effort to verify that in such a case, the consent is given by a holder of the parental responsibility over the child, taking into consideration the available technologies. So even though it's not a specific mention to age assurance, it could eventually be interpreted that to be able to distinguish that the user is actually below the age threshold and therefore there is a consent, a parental consent that is needed, there might be a need to implement age assurance technologies, although this is not explicit and neither mandatory. Under the GDPR, for example, in certain low-risk situation, it would be completely sufficient to have a simple self-declaration method to provide that the user is or not a children. And then we have the Audiovisual Media Services Directive, which provide like actually mention explicitly age verification tools in two instances. The first one relates to audiovisual media services.
Martin, sorry to interrupt you.
Yeah.
The PowerPoint is still on the page 2. Maybe if you can refresh it and do, and also place it in PowerPoint format. Yeah, now we can see impact on fundamental.
Okay, sorry for that. So it was stuck on this one. Can you see?
Yeah, but we can see it like very small. So maybe we can try to maximize the screen.
Okay, the presenter mode is not working, I guess. Okay, so thank you for letting me know. How can I do? So if I do this, you don't see me showing the slides, right?
No.
Okay.
Let's enlarge them as much as possible.
Yeah. If you can like manually enlarge.
Do you know if there is a way to make the presenter mode through the service, through the call? So you still don't see me presenting here.
Yeah.
No,
Probably it's a matter of your, I mean, I don't know, the program that you're using. Sometimes it's, yeah. But now I think we can see if it's not.
Okay, I will keep it like that. So apologize for this. So yeah, maybe so this slide you saw about the different risks
we
and the
can,
legitimate
the
objective.
next one.
Yes, okay. So that was about like the different fundamental rights and the access by different users. This was about the necessity and proportionality tests. And here we go with the GDPR, and now we are there with the AVMSD. Now you can see my slide, right? Okay. So regarding the Audio Visual Media Services Directive, so it has two provisions that relates to age verification tools. The first one concerns traditional audiovisual media services that may impair the physical, mental, and moral development of children, and it creates an obligation for the providers of those services to ensure that minors normally not see them. And that includes several measures, which may include age verification tools or other technical measures. And the directive precise that those measures should be proportionate to the potential harm, and that only for the most harmful content, then, so for example, gratuitous violence or pornography, the stricter measure should apply. And it also specified that the personal data of minors that have been collected or otherwise generated by the media service providers for respecting this obligation shall not be proceed for commercial purpose, such as direct marketing, profiling, and behaviorally targeted advertising. So that's a first safeguard. So first of all, is not mandatory to implement age verification tool. It's an option to be able to make sure that children are not exposed to an inappropriate content. And then there is the safeguard of making sure that once the information is collected, it should not be proceed for commercial purpose. And then we have basically the similar obligation, but this time it was from the revision of the directive in 2018, and it concerns video sharing platforms, which should have appropriate measures to make sure that their program or the program that have been generated by the user of the platform and which can impair the physical, mental, and moral development of children are not accessible to them. And again, there is a requirement of being practical and proportionate, and those appropriate measures, when appropriate, can include age verification systems and parental control systems. Again, with the requirement that the personal data should not be processed for commercial purpose. Finally, we have the DSA, which is the main regulation that like attract the most debate right now and attention, with three different provisions. The first one being Article 28, which basically require that providers of online platforms that are accessible to children, to minors, should put in place appropriate and proportionate measures to ensure a high level of privacy, safety, and security of minors on the service. For example, they should not present targeted advertisement based on profiling, when using the personal data of the recipient of the service, when they are aware that with a reasonable certainty that the recipient of the service is actually a minor. So basically, no targeted advertising to children when you know that the user is a children. And there is also actually a safeguard in this provision, saying that to comply with this obligation is not actually obliged to process additional personal data in order to assess whether the recipient or not is a minor. Meaning that, for example, if you know that your audience is a children because you already target your service towards a children audience, you can apply this by default without necessarily having to implement age assurance methods. And something important to keep in mind also about Article 28 is that it's only concerned online platforms. And there is a definition in the DSA of what is an online platform. And basically is a type of hosting service. And a hosting service basically means that at the request of the recipient of the service, the service will store information provided by the user. But the online platform has another features that makes it an online platform, which is the dissemination of that information to the public. And that is not that this opportunity of disseminating information to the public is not minor or purely ancillary features of another service. And so, for example, in the recitals of the DSA, they clarify what it means. Sorry. They clarify what it means to disseminate information to the public, which means making the information available to a potentially unlimited number of recipients, and that this is the principal feature of the service, which actually, when you analyze this definition, exclude a lot of different services. And from my own expertise, I'm working a lot with gaming platforms, games, and actually in the gaming sector, we see that very few games. I mean, there are a lot of games that allow the dissemination to the public, but often to only limited number of recipients, and therefore may fall out of this definition, which can create problems, because we see that a lot of other provision, including the provision of protection of minors, is really linked to this necessity of being able to disseminate information to the public. So that's the first limitation, but I won't discuss too much about it because I'm a bit cautious with the time remaining for the rest of the presentation. So regarding other provision inside the Digital Service Act, we also have Article 34 and 35, which are specific obligation for very large online platform and also very large online search engine, so VLOPs and VLOSs, which have the obligation to both identify systemic risk and mitigate them. And to be considered very large, you have a high threshold, which is basically having more than 45 million users in the EU. And you also need to be actually considered designated as a very large online platform or VLOSs by a list that the Commission is actually determining. And so among the different risks that are considered systemic risk, there are notably any actual or foreseeable negative effect on the exercise of fundamental rights, which includes the rights of the child, which are also enshrined in the Charter of the EU, and any actual or foreseeable negative risk in relation to the protection of minors, but also the person's physical and mental well-being. So that's again like the risk that I was mentioning in the introduction can be considered systemic risk when they are present in a very large online platform, and therefore to mitigate those risks, the provider of very large online platforms have to take mitigation measures, which may include, where applicable, targeted measures to protect the rights of the child, including age verification and parental control tools, but also, for example, tools that help minors to signal abuse or obtain support as appropriate. So again, it's not really an obligation per se, it's rather optional. And each time you have safeguards, which are safeguards of proportionality, and also data minimization and purpose limitation if we look at the AVMSD, for example, when it cannot be used for commercial purpose. So that's to give you a rather brief overview of the European law as it is. There are currently some proposals that wants to go further with age assurance, as mentioned by Johan in the introduction as well. But I leave that maybe for further discussion, and so I will keep going with the presentation by sake of time. I would like still to discuss the guidelines that have been issued by the European Commission on Article 28 of the DSA during this summer, which are non-binding guidance that are aimed to help online platforms to comply with their DSA duties, and therefore list a series of best practice and appropriate measures that can be done by platforms such as privacy by default, safety tools and controls, how to prevent harmful contact and content risk, avoiding addictive feature, etc. And there is also a section specifically on age assurance requirement that request and emphasizes the need for a proportionate implementation of those systems, having a risk-based approach in mind. So first assessing what are the risks bring by the platform and what are the risks bring by the age assurance themselves as well, to be able to select the right methods and to see how to implement it. And in general, for the development and implementation of age assurance systems, it's important to make sure that they are accurate, reliable, robust, meaning that they cannot be easily circumvented, non-intrusive, so they respect privacy and data protection, and also non-discriminatory, to make sure that all type of population and demographic can use those tools. The guidelines also make reference to a statement that was done by the EDPB, so it's the European Data Protection Board, which was in this statement re-establishing the importance of the different principles that are enshrined in the General Data Protection Regulation, such as data minimization, purpose limitation, but also the security of the personal data that are processed and the rights of the data subject, as well as the accountability of the different providers of age assurance system. And finally, the Commission in this guideline propose a layer approach to the implementation of age assurance methods, depending on the different risk that the service provides. And so here, just to give you first, before discussing this layer approach, just to give you maybe a reminder of like what are the different age assurance methods. So we first list self-declaration, which is like the less intrusive, but also the most ineffective. Which is why the whole age assurance debate started. And then we have different layers, like first estimation that will only estimate the age, but without a high level of certainty. And then we have verification, which means that the age has been backed up by an actually official identity, an official document relating to the date of birth of the user, and therefore providing a higher level of reliability. And so in the guidelines of the Commission, they recommend that age verification is the only suitable methods, or at least like level of reliability, of the age assurance of the age proof for different scenarios. The first one is when there is a law that actually restricts the access to goods or contents, such for example to 18 plus, so being not a minor, for example pornography or gambling services. Where there is services that are designed for an adult audience only, for example, dating apps, or that those apps pose risk to minors. When the terms and conditions also contractually limit the use of the service to being above 18, or when there is a high risk on the service and that only age verification can protect minors in that circumstance. And then the second layer is where age estimation could step in, or still based on age verification. And so when they accept age estimation, is for low risk, such as, for example, when the terms and conditions require a minimum age that is lower than 18. So, for example, if I'm thinking about social media bans, often it's more regarding 16 or 15, or when the risk associated with the platform are rather medium than higher, which depends on the service provided. So actually being able to distinguish between this different scenario require impact assessment, which
Sorry,
yes.
we are a little bit.
Yeah, I'm so sorry about
No,
the
no.
time.
I mean,
Yeah.
I'm aware that the EU legislation
It's complicated.
requires time to be presented, even in a summarized manner. But
Yes.
we need to wrap up. I'm absolutely aware of the challenge.
Okay.
Yes.
Maybe just a last remark is important, and maybe since like some representative of the Commission are also present in the call, they can like further develop on that. But I really wanted to talk about the European age verification solution, which is something that the Commission have launched recently to try to propose a privacy preserving solution to age assurance, which would be based on digital identities. And so far, they have a white label app that is open source and that member states can and platform as well can adopt, and which has some privacy requirements, such as the zero knowledge proof, meaning that only the proof of age that being above a certain age threshold is communicated, and no information about date of birth or name about the users. And there is also a requirement for double anonymity, which still has to be implemented if I'm aware of the latest development of the prototype. But basically, it would be a solution that would allow to preserve the privacy of users while also making sure that children are protected, and that would be based on governmental digital identities, which can also, in the long term, maybe provide some challenge of like a full adoption across the EU, but also public acceptance of relying on governmental based solution, for example, for sensitive services such as porn as an ID. I'm very keen to develop on that further, but I also understand the time constraints. So please, if you have any question and we have time to develop that further, it will be my pleasure. And sorry for
Thank you. Thank you. No, thank you for the
long.
effort. Again, I mean, it's a challenge. So, I mean, I think that it shows already. It's a statement by itself. I think with the exercise that you had to do. Thank you.
Yes,
Thank you very much.
Thank you very much, Martin. This is, for example, a good reason to have a second webinar to further develop on this. So thank you very much for the interesting presentation. I am now going to pass the floor to Marianne, and just as a reminder, the Q&A session is at the end of the 3 speeches. So if you have questions, just write them down, and we will deal with them at the end of the 3 speeches. So Marianne, the floor is yours.
Thank you so much. And like Martin, I think, trying to face this kind of challenge and explain the complexities of any particular region that's trying to grapple with these issues is a challenge. So I will say, as a kind of introductory remark, that I'm going to try to keep things very broad, and we can talk about the details later because it is so complicated. So the United States, as I'm sure comes as no surprise to anyone, is in a bit of a state of transition at the moment when it comes to protections, both of freedom of expression generally, but also, of course, in terms of regulation of the internet. The political situation has changed so rapidly in the last few months even, but also over the last few years, that a lot of typical settled aspects of how we approach these questions of obscenity or harm or minors or freedom of speech have become very, very unsettled lately. So I will try to both sort of move forward to say we're at a moment where you could have simplified the United States' approach to a lot of these issues as very hands-off, very deregulatory, more erring on the side of we'll just let everything, even harmful content, flourish in the name of the First Amendment, in the name of freedom of expression, and especially when it comes to online spaces. That I think as a generalization was true about the US's approach. And then we've seen this very sort of whiplash kind of effect in the last few years, where there's been much more appetite for restricting content, for regulating certain types of speech. And this is not, there is no way to really talk about why that has happened without talking about the political nature of what has changed and how concerning it is to some people watching this play out, including those of us who have always been concerned that there's been too little regulation, especially for harmful content, being very concerned that the moment we're experiencing now with the newfound willingness to regulate is not the outcome we were hoping for, because what is being done here is not really about targeted concerns that are well evidenced and have a nuanced approach to address them, but rather larger political questions that we have to be concerned about and weaponization of certain types of regulation. Okay, so then I'll back up and say where we were and say a little bit about where we are now. As many of you know, and was already referenced in the introduction by Juan, that in 1996, the United States decides that there needs to be some kind of statement, some sort of legislative action about the internet. There were two kind of competing emotions about the internet, and I think this is true about basically all of America's, the American approach to the internet and to speech generally has been this very bipolar, we love it so much, we think we're the best in terms of protecting speech, and we're also extremely censorious. There are so many things that we just assume fall out of the realm of free speech that we feel like don't get those protections. And we assume up until fairly recently that everyone agrees with us about both of those things. And so there's, on top of the inconsistencies of the applications, there's just not much agreement about the underlying definitions, let's say, of these terms. And by these terms, I mean free speech, obscenity, minor safety. What does it mean to protect a minor? What does it mean to think about the interests of children? These are all things that people in America say they care about, but they mean very, very different things by them. And we also have, on top of that problem, that especially when it comes to our Congress, the typical, at least when it came to a few decades ago, it's changing a bit now, your average age of a legislator was someone who was not going to be particularly well-versed in developing technology. So we're in the hands of the people who are supposed to be figuring out the legislation and the effects of certain technological developments. You had people who oftentimes didn't understand them and didn't really do research into what might be around the corner. So 1996, excitement about the internet, concern that it's going to mean something terrible for children, creates this law called the Communications Decency Act, which was intended largely to keep children away from bad material online. And that definition of what was bad for children was pretty broad. And there's this long-standing exception to the First Amendment categories of protection called obscenity, which is actually a pretty capacious and very mischievous kind of exception. And it's mostly based on moral offense. So we have that large category, and you have on top of that children's access to that category that makes people very anxious. And so most of the CDA was intended to stop children from getting access to obscenity. But some people in Congress were worried that what that would mean was we were going to censor the internet. There was going to be too much pressure put on platforms and services to try to keep obscenity, that broad definition, away from children, broadly defined. And so one piece of it that became known as Section 230 kind of went in the opposite direction and very much indicated that companies should do whatever they thought was best, and they should try to self-regulate. And that would be the best approach for going forward, not only for harms to children, but for harms of any kind. So kind of in different directions. And what happens to pretty much all of the Communications Decency Act is that it's struck down as being unconstitutional. That is, the Supreme Court says this definition of obscenity is very tricky to apply to the internet, because the definition of obscenity was intended to take into account local community standards. And online, that was going to be very hard to do. It was very vague. It was very overbroad, that what the law was attempting to do. And the concern was that's going to be a First Amendment violation. So that all goes away. The one part that stays is Section 230. And that is that part that basically says, do what you want, companies, and we will try to let you self-regulate. I'm overstating this here and leaving out some nuances, but that was more or less what was left of the internet regulation. And I say that in part because one of the reasons why we see this polarization between don't regulate and regulate everything is because there's genuine frustration that when you go in one direction, you leave the entire internet open to children to access in any way that they can. And this is incredibly harmful content that they might be accessing, including things like graphic violence, suicide, drugs, eating disordered information, things that are really concerning. But the tendency has been, when we focus on minors as a legislative matter, Americans tend to focus on sexual depictions to the exclusion of everything else. And the Communications Decency Act, Section 230, in trying to sort of undo the other parts of the statute, which were too restrictive and too censorious, kind of went in the opposite direction and said that platforms and services really should never be responsible unless they want to be responsible for how people are accessing speech on their platforms. So you've got this kind of tension between don't do anything, do everything, and the don't do anything wins out. You get Congress's attempt to try to fix that by trying to have a narrower statute that says, okay, we won't say it's obscenity everywhere, but we are going to require more or less that these companies that have online platforms, that they require age verification of some kind. And that gets struck down as well as being unconstitutional. And the idea there was you should have other kinds of methods to make it so that these companies, these commercial websites, can try to separate who is a child and who is an adult before they have to provide their services. We don't want to make them fully responsible for making those distinctions, because it seems like it's going to impede innovation and it's going to impede adults' access to content. And that was considered to be kind of where things stood for decades, was that you can't impose things like age verification requirements on websites. If they want to impose them themselves, they should be allowed to do that, but that there should not be a law that tells them they have to do it, because there should be other alternatives to explore, including things like filtering technology, or as many times these conversations go, parents should have better conversations with their kids, which is maybe a little bit unrealistic. So that's how things were, very deregulatory, and we have the internet that we have, which I think is worth pointing out that it's not just a question of proliferation of harmful material to minors, but to everyone. There's non-consensual pornography that affects adults as well as children, deep fakes, misinformation, conspiracy theories, radicalization, extremism, none of which really got regulated because of the direction that was taken in 1996. And then you have a revitalized interest in children's concerns and sexual concerns in particular. And here's where I would have to say, when we're fast forwarding to these last few years, to mention that that concern about children, as often happens, can be a combination of good faith concerns that we are really worried about the kinds of things kids can access online, as we should be. We might also be worried that we as adults want to control what kids see online because we have political and other feelings about what's appropriate for them. And then we might have people who are just misunderstanding what things are genuinely harmful versus what experts actually tell us is harmful for minors. And all of that can be mixed into this impulse to say, let's do something about children and the internet. So what you get in the last few years is a very strong effort on the part of especially Republican conservative legislators trying to say, let's start talking about regulating obscenity again. Let's start taking more shots at this idea that you can keep it away from children. And that's combined with, I think, a lot of Democrats, and it's a bipartisan effort in Congress for several pieces of legislation to say, we all care about these issues. Let's come together. This is the one thing we can be bipartisan about. But what happens that's different in the Republican context is this thing I'm sure some of you have heard about if you're following American politics, is this document produced by a very powerful nonprofit organization here called the Heritage Foundation, called Project 2025. And one of the planks of that project for America was to rid ourselves of pornography, that pornographers should be thrown in jail. Pornographers, not obscenity, which is a different category, and that the implication or the definition of pornography that was given in this document that has proved very influential for the Trump administration the second time around is that pornography is basically anything that deals with LGBTQ content. And so now you have a very political dimension to what was already a complex question about what is harmful to minors. And to oversimplify once again, one of the concerns coming from people in the child safety space and in the free speech space is what is really going to be happening here is that concern for child safety is going to be used as a vehicle to ensure that no one gets access to certain information that goes beyond heterosexual, Christian, very narrow set of ideals of what is considered to be right and proper for Americans. And that this is going to become a very powerful tool to justify imposing restrictions on Americans' access to free speech and to expose their private data in all sorts of ways by using age verification laws. And so that brings us all the way up to Free Speech Coalition versus Paxton, which is this case that is decided just this year. And it's not a federal law, it's a state law, it's Texas, that essentially tries to do something very similar to what the previous federal attempt had been, which is to say, when it comes to material that is harmful to minors, commercial websites, and it's a very strange definition of which ones count and which ones don't, but they're going to have to use some kind of age verification measures. Now, the obvious question for everyone, I think, was why would this case come out differently than the one previously that dealt with a very similar law? And the answer is there's no good reason except that political calculations have changed. And this is actually, at least in my estimation, a much worse law because of the way that it defines what is harmful to minors, or rather does not define what is harmful to minors, makes no distinction between what would be harmful to a 17-year-old versus a 2-year-old, only requires that you have age verification if the site in question has over a third of its content is this kind of content, which means that if you're just producing huge amounts of other kinds of content, you can have all the obscenity and all the graphic, sexual, and dangerous material you want. And it also won't apply to social media platforms or to search engines. Why would that be the case when those happen to be the most prominent sites for many minors to find harmful content? I think it indicates that there is more bad faith here than there is genuine concern about child welfare. So you have Justice Thomas writing the opinion saying, well, we're really worried about damage to minors. So we think that this is a perfectly legitimate way to control that. To the extent that it burdens adults' access to this information, we consider that burden to be very much a kind of a light one that we shouldn't be that worried about. And even though this is just a specific ruling on one Texas law, there are 25 other states that have similar ones, and it has basically been a signal to any state legislator and also, of course, to Congress. If you want to do something similar here, you can. And again, we can go into the details about why this is so harmful, both in terms of what it will do to minors, but also what it does to adults. But I'll be, in the interest of time, I'll just emphasize two basic points. One is, as respected child safety advocates have said about this law, including the International Center for Missing and Exploited Children, this is, of course, no solution is perfect. Age verification is an imperfect way of trying to do something very noble. But the point is that it can't be something that is going to be worse than the status quo, or at least we shouldn't support something that is worse than the status quo. And the argument of child safety experts is say this is worse because you will hit mainstream porn sites that are actually have better quality safeguards and have less of the worst material you can think of. They will have these age verification measures applied to them, which means that when a child encounters them, they will likely divert And where they're going to be diverted to will be all of these user-generated sites that have no concerns about age verification or about any kinds of quality controls, really dark areas of the internet, because they won't have any of these measures in place. So we'll be moving kids away from those maybe less harmful to more harmful. And because of how over-inclusive the harmful to minors category is, moving them away from important information, for instance, about transgender identity or about birth control or about how to have safe sexual practices. So the concern there is that it's not just that it's imperfect, but it's actually going to do active harm. And then, of course, the other concern is, what does it do to adults' access of information? To the fact that people are going to have to give over private information that is likely to be hacked, to be exploited, to be used for extortion, means that a lot of people won't be able to access those sites either. To the extent that we think, oh, well, is it a big deal if you get to access fewer porn sites than you were before? Whether or not we want to credit that as a kind of response is one question. The bigger question is, if pornography is going to be defined, or harmful information is going to be defined so broadly as to include purely political or at least politically motivated categories, as we've seen the Trump administration be willing to do, to simply declare one day that terrorism means everything that criticizes Trump, something similar can happen when it comes to these other categories. We should all be very concerned. So I will leave it there.
Thank you very much, Marianne, for the enlightening presentation, and also I appreciate for sticking with the time. So thank you very much. Again, I'm sure we are going to have questions, but that will be at the end. So without further ado and without wasting everybody's time, I'm going to give the floor to Agustina. So please, the floor is yours.
Hi, everyone. Thank you so much for putting this panel together and for inviting me to join. It's been an interesting conversation so far. I'm going to try to keep it short. Looking forward to the Q&A section. So I'm not an expert on children's rights. I direct a Center for Studies on Freedom of Expression. So I'm going to look at this issue, and we've been looking at this issue from a freedom of expression perspective. A lot has been said about the European setting. Yeah, just summarized for us what the regulation in the US is like. I'm going to focus specifically on the inter-American system because I am the Latin American in the room. We have a common set of human rights standards that is gathered under the American Convention on Human Rights, and Article 13 is the one that rules over freedom of expression. Interestingly, the American Convention bans any prior censorship and promotes ulterior liability only as a measure of redress for abuses to freedom of expression. The only exception that the American Convention has is for minors.
Sorry, Agustina, we have a problem with the sound.
Oh, I'm so sorry. You cannot hear me?
Yeah, it goes on and off. I'm not sure if it's the connection or it's the computer.
It may be a connection. So I'm going to try to move over here and see if this works. Okay? Are you hearing me better?
Yeah, let's try.
Okay, so I was saying that the American Convention bans prior censorship, and that the only exception is for children in public entertainment or in public events. This was meant for theaters and cinemas, that kind of entertainment.
Sorry, it goes on and off. Maybe. No, do you have
I don't know what to do about this.
Sorry, sometimes help if you turn off the video function. Maybe the audio will be a little cleaner.
Yep.
Maybe. Hope so. Let me know. I'll change places again in the pursuit of a good Wi-Fi connection. So children are obviously regulated differently, and it's easy to see how this was a low-hanging fruit when speaking about regulating the internet, regulating platforms for different purposes. I think there are maybe two main conversations here that are of some concern, to me at least. One is an that has grown globally. Pessimistic approach of the internet. We were just hearing Marianne reflect upon the different harmful kinds of content that circulate online and how those may impact different communities, including children. But there's an impeding need to do something. And that impeding need to do something makes this particular topic quite a low-hanging fruit. Is who doesn't want to protect children, right? Everyone wants to protect children. It makes sense that we all want to protect children. So it's an easy topic, both socially, politically, to garner support around, and an easy point where to start. The other major point that I want to make is any regulation of the internet so far has, for the most part, being interpreted broadly. There is no reason to believe that this particular regulation may be overly interpreted as well. So one is, again, a very pessimistic view of the internet that makes this a very low-hanging fruit to regulate, and is perceived as a pressing need to do something about it. Second, a way into regulating content on the internet that can be easier than other more complex issues, or issues that may not have social support and political support across the spectrum. So I think this makes this particular topic a topic of attention and concern for free speech advocates everywhere. And the issue is not easy to address, or at least it hasn't been easy in the Latin American region. And as far as I've seen, it hasn't been easy in the European Union or in the United States either. There's a technological discussion. What means can we use to do an age verification that complies with the requirements that we legally want to see in any age verification system? What are legal means to do that? How are we going to implement the age verification measures? Who are we going to implement them? How is jurisdiction going to work? And to Marianne's last point, how do we make sure that the effectiveness of these measures is as wide or as effective as we would like to see them? Pragmatically, the fact is that a lot of websites are already using age verification means. A lot of platforms are using even biometrical data to verify whether they are facing children or not. Think about financial institutions, banks. A lot of marketplaces are already using these kinds of technologies in different places, at least, again, in Latin America, with no framework whatsoever. So, as far as I've seen, and I'm not a children's rights expert. I study freedom of expression and I promote freedom of expression. But a lot of the discussions in which I've been a part to, this age verification issue has been addressed as a sort of zero-sum game. Age verification, yes. Age verification, no. I am kind of wishing that we could have a more nuanced discussion about what exactly are the cases that would merit age verification. I truly appreciate the European Commission's effort in the guidelines to provide some clarifications as to where they think it could be mandatory and where they think it could be optional. It's still, as Marianne has said, regarding the interpretation in the US, quite broad, in my opinion. Just like to transfer the risks approach that the DSA has taken. I think there are legally redressable risks that are identified in laws, and that the DSA incorporates new risks that have not yet been defined within any law. I think this is particularly problematic when we open categories where age verification could be demanded of platforms. A second thing that I would say is I think there's a legality issue. We have not yet discussed which cases concisely, whether it's going to be content, whether it's going to be services, or whether it's going to be by risks that we determine what needs to be under an age verification requirement and what not. Obviously, the broader one is risks, because risks can be entrenched within services and within specific pieces of content. But the kind of regulation, the kind of demands that we can make are radically different, and the implications for, even for access to information for minors, be different, whether we choose to regulate by service, by content, or by risk. So I think we need to have that conversation first. Second, and last, and I'll finish with this. Once we have decided, each legislator has decided restrictively which cases are going to merit age verification. This, again, has to be done following the legality, necessity, and proportionality test, and they should be interpreted narrowly as possible. Once we have narrowly described which services or contents or risks need age verification, then we need to figure out under which conditions, and those conditions also need to meet the legality, necessity, and proportionality principles. So if that technology doesn't exist yet, maybe we can demand that it be created, or we can creatively think about what kind of technology we need to apply this, again, very narrowly construed restrictions when they are merited. That's all I wanted to say. Thank you so much.
Thank you. You had us glued to the screen, not only because of the interest of what you were saying, but also because we were trying to really understand you. But I think that we all got the full meaning of what you are trying to explain to us. So thank you. Thank you very much. First, I will ask if there are questions from the audience. Otherwise, if so far, I mean, you drop a message in the chat. Otherwise, I mean, I wanted to ask Martin first, in light of what you have presented, the first obvious question would be, to what extent EU legislation is consistent, in the sense that we have different layers. We have the GDPR, we have the DSA, we have the ABMSD, we have different laws that have been adopted at different moments, no? And as a matter of fact, I mean, some authors have pointed at that, the fact that between the GDPR and the DSA, there might be issues of interpretation. So at this point, and do we need some sort of a reform that I don't know, I mean, clarifies a little bit the framework, because now we have so many layers when it comes to the regulation of digital services? That would be one question. And the other question is, do you think that when it comes to these matters, there's a risk that member states basically do their own thing based on their own political interests and make things particularly difficult for the Commission, considering the political sensitivity of these matters, so that we have a patchwork of regimes depending on the member state?
Thank you, Owen, for this question. Regarding the first one, I think, yeah, it's very how to say, like it keeps coming back about the interplay between different European legislation, especially between, for example, DSA and GDPR. Gladly, we had the EDPB taking a guidance recently on this. Actually is still under public consultation. So if you didn't had a look yet, I would recommend maybe looking at it and provide feedback. But regarding the actually, like my take on this interplay is really relying on the different scope of those different provision. The GDPR being by its name general and apply to most situation where personal data are processed, while the DSA is really, especially when we talk about age assurance or protection of minors, is really targeted at only online platform, which has a restricted definition. I do think this can be problematic, because there was a lot of interesting provision in the DSA to try to minimize contact risk, to try to minimize consumer risk as well. When we think, for example, about Article 25 as well of the DSA regarding the prohibition of dark patterns and the relationship it has with the GDPR and also the unfair commercial practice directive. And so maybe it was a missed opportunity to restrict online protection of minors to the online platforms themselves, meaning that they have to be able, like the user should have the possibility to disseminate information to the public, because we see that many other type of services also have this type of risk without necessarily having this condition of public dissemination. But at least the GDPR provides the baseline for having some protection, and just taking the GDPR itself. If we think about services that would merit to protect children on the basis of their personal data, it can already provide a first layer of safeguard as well, without necessarily having to think further about age verification methods, thinking about other type of other alternative measures to protect children. Now on the other question regarding the patchwork that we're now having in Europe, and how it makes things difficult to harmonize at the EU level. We already seen that this is the case. It's already happening. We see like France that is very prominent into regulating, and has also it's developed some requirements which from my perspective, I think goes in the right way, with the double anonymization principle of that the issuer of the proof of age doesn't know neither how this proof of age is actually used. But we also have other countries that are like do not necessarily see double blind as important, or rather rely on other type of methods. And I think that especially with the newer debate on whether or not banning children from social media all in one, I think it's important to bring some clarity, and like several leaders have already called for harmonization at the European level, which would make sense as well. So it brings a a lot of responsibility on the Commission again, but I think the guidelines from the Commission on the Article 28 was already a good first step, and especially in the fact that it was putting the proportionality and the risk-based approach as a key requirement. So now let's see if the next step is to actually make that more continuous, like binding for other or government at the national level, and we'll see what will be the next step of the Commission in that regard.
Thank you. Thank you very much. I also wanted to ask Marianne, maybe, I mean, this is taken too far, but is there a risk of a mutation of the jurisprudence around the First Amendment to, let's say, have a broader understanding of the public interest that might justify introducing certain restrictions, or let's say changing the type of scrutiny to introduce considerations, even moral considerations that until now they had not been considered, at least in a substantial way? Or maybe that's too much in terms of pessimism.
No, I'm afraid it's probably, if anything, it's maybe not enough pessimism, and that we have. But I guess the one clarification I would say is that the part of the reason why the United States is in the position it's in is because we have constantly mythologized our own status as free speech protectors, even though for decades, ever since the 1950s and 60s, we've said obscenity is not protected by the First Amendment. That doesn't actually conform to the idea that we are incredibly open to freedom of expression. We say that a lot. If you look at our history, I've written a book about how if you actually look at the times when Americans have tried to speak out against racism or against sexism or against classism in the United States, they have not been protected. They go to jail, they get shot, they have their newspapers burned to the ground. We tell ourselves a story that is not always matching up to reality. And so part of that kind of inertia of assumption that we do have these free speech credentials, right, makes us think that whatever we do is also somehow wise. And so now you have an administration that is perfectly willing and ready to weaponize that and to say, well, let's, everything we say is free speech is free speech. Everything we say is censorship. It just so happens the things that we think are free speech are the things that go along with what the administration wants, and everything else is censorship. So I think we do need to be very worried about that. What worries me most about the Free Speech Coalition versus Paxton case that was decided this year is that even though it looks like it's just about age verification and it's just about Texas, this is a First Amendment case where the court says intermediate scrutiny for something that is absolutely content-based. That is very alarming, right? That we have a court that signs on to this to say, this didn't used to be a political divide. That used to be clear that if something was content-based, you gave it the strictest form of scrutiny to ask, as Martin and Agustina are saying in other contexts, they're the same concepts, I think similar, that it's got to be necessary and proportional, and the fit between what you are trying to accomplish and what you actually have imposed as a regulation needs to be very, very, needs to be really, really precise. And for the court to say, we've just decided that it can actually be much more relaxed in a case where there's no reason to do that, and to not admit that what is happening here is essentially an overruling of the prior decision. Justice Thomas says, not overruling anything. These are all perfectly consistent, and that's not true. So I'm very worried about the deceptiveness, the open deceptive nature of trying to say, no, don't pay attention to what is actually happening. Just hear me when I say we've always done it this way, right? It's the word Orwellian gets used too much nowadays, but it really is. It's this idea that it's always been like this. Nothing has changed. We're just doing the First Amendment as we always have, when we definitely are not.
Thank you. I have a question for Agustina, but first I saw that Aleksandra wanted to say.
I realized that I might have clicked that hand image a little too fast. Sorry. But I was just thinking, well, first of all, Marianne, thank you for saying that. And I have to say, when your book was out, it was very eye-opening, because it was very much like, wow, instead of speak truth to power, it's very much like speak truth if it suits the power. But and also in light of everything that is being said about the DSA as the censorship tool, but okay, that's maybe a bigger topic. But I had a question for all of you, but it links a bit to the concerns that Marianne mentioned, about the implementation of such solutions and tools. And I'm mainly thinking about what we've seen happen in the UK now this summer when the UK Online Safety Act was implemented, and then basically requiring that hosts with websites that host pornography or adult content requires highly effective, as they call it, age checks, right? So that would be face scans or requiring IDs. And then immediately, people started using VPNs and trying and coming up with all sorts of creative ways to circumvent all these checks. And as far as I know, the goal was, none of it was really achieved. And at the same time, and this is what Marianne mentioned, is that a lot of people got directed to smaller websites that do not intend to comply with any of the regulations, actually being pushed into more unregulated hardcore content that maybe they would not have encountered if they used just Pornhub or YouPorn. So is that it seems inevitable when you're trying to introduce such solutions, or is the one proposed by the Commission actually going to help with that? Like, anybody has thoughts on this? Because it seems like we're going to run into this issue every time with any of those ideas.
Anyone, Agustina, that you perhaps didn't still have the chance to answer a question? Or
Yeah, sure. Well, I think the law creates incentives like anything else, and it can create incentives for the flow of information, or it can create incentives for censorship. I think that's what Section 230 did. I think that's what the e-commerce directive in the European Union did. I think that's what law does. It's what we ought to do, and not what we can or cannot do. You can cross a red light, but you ought not to, or you shouldn't. That's what the law says. So I think thinking about the ways in which the law can be abused or not abused, but thinking about the way that people can circumvent the law is interesting, and you can take it to the effectiveness. But I also think there's always a percentage of people that will find a way to circumvent the rules and the laws. A lot of the criticism that I've seen to people defending freedom of expression standards and privacy standards when criticizing regulation proposed to protect children are, you're proposing us to do nothing. And that argument comes very hand in hand with this argument of ineffectiveness, which I totally understand and I totally agree with. But I think we can imagine that a lot of people, not all, but a lot of people will be thinking twice at least. A lot of smaller children are not going to be able to VPN their way to pornography. So this will not be an issue for a 9-year-old. It might be an issue for a 15-year-old. Maybe it's a way to resolve some of the issues maturity, independence, a development of the child. I don't know. But I think the conversation again is missing a fundamental point, which is, where do we absolutely need this? Narrowly defined and narrowly tailored. Where, in which individual, specific, non-ambiguous cases do we absolutely need this? And I honestly don't think it's for social media, to be quite honest with you. I think it might be for dating apps, maybe. It definitely is for gambling. But then again, if we can count them with the fingers in one hand, then we've already moved way forward the conversation on how to protect children and to protect them from what exactly. I got struck by Marianne's comments about the lack of consensus as to what does it mean? What does any of this mean? And I think it's different in different cultures, and I think the ambiguity is said in every culture, even if the differences are clear. What is the interest of the minor? What is in the best interest of the minor is a mess to understand, and it's been messy for judges, and it's been messy for parents, and it's been messy for everyone. So maybe let's get a few clear-cut cases where there's a few consensus that this is in the best interest of the child. Again, gambling, maybe dating apps, but narrowly defined. And if we cannot legally define this thing, then it cannot be mandated. I think that's a good way to go. Will it address every risk that teenagers and young children face online? No, it won't. Do we need to address every risk? I don't think so. There are risks when they cross the streets, and we teach them. And there are risks when they read the newspaper. They might not understand what they're reading, and we teach them. And there's no way we can protect them from every single risk. That's why I think we need a more nuanced conversation and a narrowly tailored definition of what we want to regulate.
Thank you, Agustina. Martin, yeah, I think I was going to invite Martin to speak, because when we were interrupting him all the time, he was trying precisely to tell us about the guidelines that try the guidelines of the European Commission on how to interpret Article 28 of the DSA, that try to take this kind of risk-based approach and kind of gradual approach that might perhaps help in this endeavor, even if, of course, it's very complicated.
Thank you, and also I wanted to actually react on what Agustina was saying regarding and the question of Aleksandra. I think these circumvention issues really highlight the crucial need to really develop other alternative measures to reduce the risk of our children on the different services. As highlighted by Agustina, there are some services that are like by themselves, by design, are problematic and harmful, such as like pornography, gambling, etc., where you would need age assurance. But thinking about social media or gaming or other services, there is a lot to be done before having the age assurance step. And from a children's rights perspective, I do think that given the tremendous importance of those digital services for their life, like we see how prominent it is in their day-to-day life, they will always find a way to circumvent or to go back to other type of services. We want indeed shield them from any type of risk? And even if we do so, what would that imply when they would actually turn into age and be confronted with a massive amount of risk that they never learned how to deal with? Like Agustina was giving the example of crossing the road. I do think thinking about supportive tools that really educate children along the way, and just measuring the right amount of risk that they can take gradually, also taking into account their evolving capacities, is very important. And just a strict ban on the service itself, as we have seen being more and more discussed either in Australia or now in Europe, is I think is very harmful in the long run for minors and younger children. So that's a quick reaction on what was discussed before. And as regard to how the European Commission try to distinguish between those different services, I do think that the risks that are listed as needing age verification are important. Like when there is a law that mandates to be not a minor, it has to be enforced. Or when there is like a very high risk that would not be able to be mitigated otherwise, then age verification could still be deployed, to the extent that the age verification system also has a lot of safeguards that prevent the abuse or of personal data, or like collecting more personal data than necessary, and make sure that those systems are not discriminative. So that's a very important point. And in that regard, maybe I have maybe a remark on again on the list provided in the guidelines of the Commission regarding age estimation, which they consider rightfully as being less effective, or at least less reliable in terms of the proof that of age that it's established, because it's only an estimation and not a verification. But at the same time, it is known that those systems often have or still have some bias and can have inaccuracy on the result that they have, depending on how they have been trained, on which data, whether those data were sufficiently representative of a wide and various demographics. And therefore, it is a bit paradoxal that, like, the Commission lists some services that pose medium risk to users, but still would allow for systems that may have a higher risk in their conception. So for example, if you want to, I don't know, taking the example of gaming, it would be possible for users to go through biometric and facial analytics to prove their age, which, depending on how the system is developed, can be very privacy intrusive and very risky, while the actual risk that we are trying to prevent the children to be exposed in gaming may be not as strict or harmful as accessing pornography, for example. So that's simply a remark, and I don't think the guidelines really explore the different type of age estimation systems and the different requirements that they should have to make sure that they are trustworthy and safety and secure. Yeah.
Thank you very much, Martin, for the comments and for the clarifications. If there are any comments, questions from the audience. Okay, I see there are no comments and no questions. So
just if I may, Elena, just say that this is, I think it's been a very interesting comparative exercise to see, I mean, how in different regions, I mean, this is a problem, even though this is the same problem, even though, of course, there are different legal constraints and different legal frameworks and principles that of course, I mean, in a way, condition the way we look into this topic. In any case, I think that we need to continue this discussion either in the format of a webinar or any other type of format. We'll post this conversation online, and we'll invite those who have been involved and all the people to continue it, and we'll see, perhaps in a different format. But I think that there are still many questions that remain unanswered. And here we are talking about, at the end of the day, about the very substance of the right to freedom of expression. So we need to be particularly cautious when taking decisions in this area. And of course, also the very substance of the right of children and the necessity to protect children. So thank you very much. Thank you to the speakers, and thanks to those who have attended. And again, as I said, we'll try to post this conversation and to even perhaps post an analysis as soon as possible.
Thank you very much again for taking part in this webinar, and also to the audience, and we'll keep it posted with other events. Thank you.
Thank you so much, everyone.
Thank you. Bye.
Bye.
Thank you. Bye-bye.
Bye.